If the UK leaves the EU without a deal on the 29th of March, data protection law will change. The GDPR will be copied into our domestic law to create the UK GDPR. UK businesses will comply with the UK GDPR, and EU businesses will comply with the EU GDPR. There is little difference between the two. The rights that the GDPR provides are the same, but enforcement differs. That's because the UK GDPR is enforced by the ICO, and the EU GDPR is enforced by authorities in the remaining 27 EU states. Finally, as the UK will no longer be in the EU, rules differ on cross-border data transfers. If you have branches in the EU, then you must comply with both UK GDPR and EU GDPR. Both the ICO and EU authorities can enforce against you. You may need binding corporate rules or standard contractual clauses in place to secure your intercompany transfers. Even if you have no EU branches, the EU GDPR can still apply if you are targeting EU customers. You might need to appoint an EU representative. Even if only the UK GDPR applies, you need to map your data flows. You can continue to send data to the EU without additional safeguards, but EU controllers can only send data to you if the right safeguards are in place. The ICO website will help you determine if you need to safeguard flows with standard contractual clauses. The EU allows data to move freely with third countries where data protection is adequate. But on the 29th of March, the UK will not be on the list of adequate third countries. The UK expects to be deemed adequate, but it could take a couple of years before that happens. You haven't got long to get ready. But guidance is available. Has your business got data ready for the 29th of March?